or disagree is tremendous. So,
Okay.
court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without fact.
If you stop speaking when I'm speaking, then I will state my grounds. And so
I
this
never
is the
requested
time.
that. You stated that, Your Honor. This is my first time requesting any adjournment.
I reserve all my rights. I don't want a jury trial.
You don't want a jury trial?
I do want a jury trial. I reserve my rights. I want a jury trial.
All right, let's slow down. You have the right to a lawyer for arraignment here today.
He does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
I've heard this story about your kids.
13 and 16 now.
Well, they need to be trained.
Yeah.
That dog has to either be in a cyclone-fenced yard, in your house, or on a leash equipped with a muzzle and accompanied by you or another suitable adult.
Correct.
That's it.
And sir, you are Amate Bay, is that correct, sir?
Yeah, Amate Bay, real party in interest in this matter.
Okay, are you driving a vehicle right now while you're on the hearing?
You said I'm driving a vehicle. Yeah, you need me to stop? I mean, I didn't
need
want
you to
miss it.
stop, sir. I can't have you
Give
driving
me
while
15
you're.
seconds. I can pull it back up to my family house, and I'll stop.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Jan. For a second, I'll call y'all when I get back.
Okay, this matter is scheduled for a hearing.
Do you recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
And did-
Objection, Jan, and hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record. When I appeal this, if this don't go accordingly.
Okay, it's a business record, sir. That's an exception from.
First-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I would disagree is tremendous. So,
Okay.
court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right, you may continue, Mr. Dewhurst.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's deed?
Objection, Your Honor. Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir, that's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtained, as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be
Yes, sir.
expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
On what grounds, Your Honor? Because I never got served directly.
if you stop speaking when I'm speaking, then I will state my grounds. And so
I
this
never
is the
requested
time.
that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So
So, Your
objection.
Honor, you don't have my deed of records right there. You don't have me as a deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standings is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He coercing Mr. Dewhurst.
Was a government record and or document recorded with the applicable recorder of deeds for this this document?
Okay, any objection to that, Mr. Bay?
Absolutely objection.
Okay, and what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no firsthand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
Firsthand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
They rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we done reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet, and I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if owed. They are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overrule the objection.
Yeah, the property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something that I got the taxes in my name? I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Your
He
Honor,
said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not
Mr.
credible.
Bay?
That's not credible.
I'm sorry. This is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson.
let me know when I'm credible to ask questions.
All right. Mr. Johnson, any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. So Brown and Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst. Okay,
Mr. Dewhurst, is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again,
okay. What's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, so this is the time to ask questions, not to argue law.
No, I'm not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed. Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor,
all the
we don't know if
interest-
this is credible
the only
foreclosure. Can I
interest
ask
he
my
had-
questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to you, to your company twice, that I sent with behalf of Matthew Brown and Rachel Brown, that they're
A common sovereign citizen mistake appears here. Once someone becomes convinced that standing, creditor status, or debt verification arguments will decide the case, every answer gets filtered through that belief. The danger is that attention shifts away from the legal issue the court is actually deciding, making it harder to address the evidence that controls the outcome.
they're yet to respond from. My notary sent it. The Notary Republic sent it.
Your Honor,
Yes.
I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr.
Okay, I'm
Johnson,
sorry.
what's your objection?
Your Honor, he's asking the witness to respond to a vague request if he has any notice, but, you know, I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the Business and Record Department, and I sent it attention to the CFO of the company.
No, Your Honor, I'm not aware of it.
But that's an argument. That's not a question. This is a
Okay.
time for questions.
No, that was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the
Oh, I
same
want,
question.
okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst, is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes, I'm
Under
sure.
penalty and perjury, do the company have it, Mr. Dewhurst?
So you may ask another question.
And okay, also, for you, Your Honor, so it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all gap procedures with this process?
Objection, Your Honor.
Understandable. So I guess the last question, again, I just want to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Your Honor, asked and answered.
No, that's not asking to answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking you that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if Your Honor or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor. Not
Okay.
at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor, but if I may just conclude with a couple things, if that's okay.
Well,
Objection, Your Honor.
if you have
Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
Okay, I'm sorry, Jan.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple of weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I asked for you to just honor my motion, honor my counterclaim to dismiss this matter because they don't have, it's not a, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I asked to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service LLC does have the right to possession and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction on July 5th, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay, all right. That's all for the record. Thank you, gentlemen.
Thank you.
Your Honor. Have a nice day.
You as well.
Ms. Leslie Langmeyer, 25B82433A and 82434. Might as well call up your co-defendant too here. James Robert Adams, 25B82370A, B, and C. Your name, ma'am?
Candace Leslie Langmeyer.
All right, so you're charged with running the dog running at large. You're also charged with 2 counts of that and no dog license. Your name, sir?
Special Appearance James Robert Adams.
All right, how you doing, Mr. Adams?
All right, sir.
All right, you're charged with dog at large, and no dog license as well.
Mm-hmm.
We have, let me see here.
I think you have
another charge. You have also 25B82371. So you have 70A, B, and C, and you have 82371. And ma'am, you just have 3 charges here. So each of you have the right, let's see.
I reserve all my rights, sir.
Each of you have the right, what's that?
I reserve all my rights. I don't want a jury trial.
You don't want a jury trial?
I do want a jury trial. I reserve my rights. I want a jury trial.
All right, let's slow down. You have the right to a lawyer for arraignment here today. Do you want a lawyer?
No, sir.
Do you want a lawyer?
No, sir.
All right. On November 24 of 24, he's alleged.
If it was something I could handle this matter today with whomever, I would be willing to do that.
I'm not gonna, I don't have anything to do with it. I'm just gonna arraign you and send you to the prosecutor.
Absolutely.
So you have a dog roaming at large on Langdon, it says, versus near Eric. Both of you do. This
Yeah,
is
you're
the same
exactly.
charge. It's November 24 of 24 at 12:19 a.m. So each of you have 2 charges of dog at large, 1 charge of no dog license. That's a civil infraction. The dog at large charges are punishable by up to 500 fines, 90 days jail, costs, or all of those. And the civil infractions are punishable by payment of fines and costs only. You also have, Mr. Adams, another charge for some reason. Let me see here.
I don't even know what that's for. I don't think I have that one, to be honest with you. I
You have
don't.
another charge of, you have 2 dog license required charges. So it looks like they just issued, I'm sorry, ma'am. So do you. You have 82434. So both of you have 2 dog at large charges, 2 dog license, no dog license charges. Those are civil infractions. Both of you have 2 of those each.
So, Your Honor, may I speak for a second?
Depends what you're going to say.
So this is, you seeing her, it's been over a year, I think.
Actually, if I can speak.
Go ahead,
Okay,
please.
so as of June 22nd, 2023, when I came for a violation of probation.
In front of me?
In front of you, yes, sir.
Multiple times. I
Yes.
remember it well.
Right, so that day when I was here in court, we had come to an agreement with the prosecutor, with our lawyer present, that from that day forward, he has full responsibility. It was known to let animal control was here as well. So as of that day, he took on full responsibility for the dogs. I was no longer to be contacted, just so I didn't
All
have
right,
to be.
I don't, you can talk to the prosecutor about that. I know
Okay.
nothing about that.
Okay.
Yeah.
All right,
But those are the possible penalties, so I want to make
Sure.
sure you understand it. Do you understand it, Mr. Adams?
Absolutely.
Do you, Ms. Langmeyer?
yes, sir.
And did you sign, read, and understand an advice of rights form, Ms. Langmeyer?
Yes, sir.
Mr. Adams?
Yes, sir.
So I just want you to know, if you plead guilty at any time, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that, Ms. Langmeyer?
Yes, sir.
Mr. Adams?
Yes, sir.
All right. Do you still wish to waive your right to a lawyer, Mr. Adams?
Yes, sir.
Ms. Langmeyer?
Yes, sir.
Give me 1 second here. I just got to get this. All right. Okay. So you guys can go and talk to the prosecutor.
Okay.
I don't remember what kind of dogs they are.
Well, I have a new one, so I used to have an old one, he passed away.
I'm going to give you a personal bond of 500, but I'm going to add the conditions when you come back here. Okay? So I'll enter not guilty pleas for both of you. You can go and talk to the prosecutor. The dogs, actually, whatever dogs, how many do you own now?
I have 2.
What kind?
One is a coonhound, a Walker coonhound, and the other one is a mastiff.
So they either have to
Mix.
be in your house, in a fenced-in yard, or on a leash, equipped with a muzzle, accompanied by you. That's a condition of your bond. Do you understand that?
I do. I have one question.
Hang on 1 second. Do you understand that?
Yes, sir.
Okay, what's your question?
My question is, so the last time we were here, I actually had a fence, like it was an invisible fence. It's not very good. They fail. So what I did buy is I have a GPS collar here. That's what, I have GPS collars that are electronic fences.
I'll tell you what I'm gonna do.
So,
We're gonna talk about all this when you come back in after you talk to the
Yeah.
prosecutor. Maybe you can mention to her what you did, all
Yeah.
right?
okay,
And I'll call all these cases when you talk to her,
Okay.
and we'll go from there, all right?
okay.
But we'll talk about the bond conditions. But as of right now, what I just said are the bond conditions. If you got some reason to ask me to do something different, I'll be glad to listen, okay?
Okay.
Thanks. All right. Did you meet with Ms. Langmeyer and Mr. Adams?
I did, Your Honor.
What are we doing on that?
We're scheduling it for jury trial. I would also like to address bond when appropriate.
James Robert Adams, 25B 82370A B C. Hang on 1 second. Seems like I'm missing a ticket maybe now. A, B, and C, and then Langmeyer, Candace Langmeyer. 25B 82433A B C And there's also 834 behind this as well. So we have, just for the record, I don't know if you saw it, Ms. Foley Carter. Got 2 counts of dog roaming at large, 2 counts of no dog licenses to each defendant.
Correct, Your Honor.
I had told your name, sir?
James Robert and
Ma'am, your name?
Candace Leslie Langmeyer.
I had told them before that I wanted the dog to remain in the house in a fenced-in yard or on a leash, accompanied with a muzzle. He talked about some other thing he had.
it's a fence. It's a GPS fence. That's kind of like the new state of the art.
What do you want to say, Ms. Carter?
Yeah, well, first off, whatever collars he has, if they are fixed with these collars, they're not working. The dogs are in the road, bothering joggers, bothering other people that are walking their dog, defecating on neighbors' property. They are houses down yonder. This has been going on for years now.
I know it has. Ms. Langmeyer was in front of me on a multitude of cases, so much where I actually threatened jail on this because you can't keep letting dogs run around the neighborhood, folks.
If they were out of the yard, we were there with them and they get back in the yard.
I'm just telling you.
I'm just, they don't like run loose. We're there. Now we're there. Now, before my boys would let them out, I don't even let them out. I am there. So if and that's why I want to see the video. I need to see what there's.
Well, here's what I'm doing.
Larry across the street has been creating issues, not just with me, with every other neighbor. And he's also surveillancing my property.
Hang on a second.
Which is against the law.
Hang on. I just can't believe it's coming to this again. I saw these up today.
I spent thousands of dollars.
Hang on. I just can't believe we are still going on and on about these dogs.
They haven't hurt anybody.
Maybe they haven't. They can't run the neighborhood.
They're not. I'm telling you, if it's 1 or 2 times.
Look, I don't know that they were not on this.
I need to see the evidence.
Yeah,
Your Honor. I really do. I need to see it because as far as I know, they haven't been.
All I know is this. I had multiple cases. I don't know if this is this your wife or girlfriend or what. I don't care. But with Ms. Langmeyer, I had multiple cases with her.
Yeah.
Multiple cases. So much so that I actually was threatening to send her to jail on dog at large, which I've never done and never threatened anybody about jail. And actually was serious about sending her to jail because I had multiple cases and complaints from neighbors, it sounded like. So now here I am 2 years later back dealing with dog at large cases again. I'm just telling you, I'm going to give you your trial, but just remember, there's no defense to this except the dog it can't be running around the neighborhood. That's dog at large.
I don't know that it has been.
I'm not saying they were.
That's why
I'm just telling you guys, I'm sticking with the bond conditions I just gave you. Dogs to remain in defendant's home, fenced-in yard, or on a leash, accompanied by the owner and equipped with a muzzle. That's it. That's the order of the court. And you're not to have any contact with prosecution witnesses at all. Now, I'm going to give you your jury trial. We'll set it up now if you want. But those dogs, look, I don't know what kind. You told me what they were. Didn't sound overly well. The Mastiff isn't exactly a little dog. Those dogs are huge.
He's a mutt. He's not that big. He's
big.
about the same size as our coonhound.
I don't care,
He's 2 years
folks.
old.
There are laws and you got to comply with them. And I just think it's silly that we've gotten to this point.
It is.
Just please listen. Yeah, but this has been going on for years. Maybe not in the last 2. I don't know. I heard you had a case with Judge Heston, didn't you, Ms. Langmeyer, a year or so ago on one of these?
No.
Are you sure?
I think,
They did, Your Honor.
No,
It was ultimately dismissed and issued against Mr. Adams.
No, I know.
Oh, yeah,
Well, I'm
that's
just
what it was.
saying, I haven't had you in front of me in at least 2 years, probably, Ms. Langmeyer.
Yeah,
but-
so it was in front of Judge Heston then in
Yeah.
June of 23. Yeah.
And
So
correct.
I'm just telling you that you can't,
If my dogs have done any damages or do anything wrong to
They
anybody,
don't have the right to run through the
as
neighborhood.
far as I know, they haven't.
Okay.
That's what I need to
Well,
know.
they have to prove that. They have to prove
Yes,
it. They
I
have
need
to
to know
prove
that, I mean, I can't, Larry, the guy across the street's half nuts. He's 80 years old. He's surveillance my property, surveillance in my next door neighbor's
Taking
property.
pictures of the kids.
And then he's actually, some of those issues, those tickets, I went and
How old
looked
are
at
you,
them.
Mr. Adams?
How am I? 51.
Then you're old enough to know that life is awful short and this is silly stuff. that we're
It's
It
talking about.
ridiculous.
is.
It's
It
insanity.
is. And I tell you what, if my dogs do any damages to anyone, I'll make them whole again.
It's not the point.
You know what I mean?
Can't
I
have
don't-
dogs running through the
They're
neighborhood.
not,
They don't
though.
run
They're not.
through
That's what I'm saying is that I don't know that they have. I don't know of any since.
Okay, so she's gonna have to prove her case. I'm gonna give you guys those bond conditions. I expect you to comply with them. I'm gonna give you a pretrial date. You're gonna come back. If you choose to resolve it then, great. If you don't, that's fine. We'll set it for a jury trial, okay?
Yes.
I don't have any problem with that, but just remember, just for whatever it's worth, awful tough for a lawyer to win or a non-lawyer to win a jury trial. I know everybody thinks this business is easy.
It's not.
It's
No,
not.
amazing.
And I'm just telling you, you have every right to represent yourself. I'm not going to deny you that right. You can sit there and play Perry Mason all you want. I'm just telling you, it's awful hard for a non-lawyer to be, you don't know what you're doing, even though you think you do. What day we giving, Lisa? Write it down. February 12th at what time?
10.
And then we'll set it for a jury if it's not resolved. Think about what I'm saying, Mr. Adams.
Yeah.
All I want is the dogs to remain in your yard or in your house or on a leash, accompanied by you or your wife or girlfriend or other suitable owner and equipped with a muzzle. That's what I want. That's what's going to happen now. What else do you have to say, Ms. Foley
I
Carter?
just want to clarify 2 points about their bond. I know that it said that the dogs need to remain in a fenced-in yard. I know they seem to believe that the invisible fence is sufficient, but it is not.
We have.
I would
we
ask
have
that the dogs
halo
remain on a
collars.
tether or leash at all times.
They have to pay.
Additionally, for prosecution witnesses, specifically Larry Krasinski, I don't want them to have any contact with him or go back to his home. They did post something on his property after the animal control officer.
Hang on a second. Let's take one thing at a time. You just got done telling me, Mr. Adams, I thought, please correct me, did you not say that that doesn't always work? The fence, the invisible fence?
We got,
No, it's the wireless ones that you put in the ground.
that's why we got them these halo
That's why I got them the
collars,
halo ones.
GPS collars.
So the one.
Well, it must
the
not
wire
be
bricks-
working, or at least if you
So-
had it, listen to me.
I couldn't-
If you had it November 24th, the dog would have got out of the yard. Right? If it was working.
If
They think that the dog was out of the yard on November 24th.
I want to see if maybe my kids let them out and they didn't put the collars on them.
Right.
They don't wear them
How
24
old are your
hours.
kids? I've heard this story about your kids.
13 and
before.
16 now.
Well, they
13 to
need to
16
be
now.
trained.
Yeah.
I want, no, that dog has to either be in a cyclone fenced yard, in your house, or on a leash equipped with a muzzle and accompanied by you or another suitable adult.
Correct.
That's it.
Okay.
I'll see you guys here on the 9th. What are we doing? The 12th at what time, Lisa?
10.
12th at 10. Will you write that on those files, please, Lisa? I gotta,
Judge,
February 12th?
February 12th. And if we don't resolve it then, we'll set it for a jury trial.
Okay.
But you guys, I would encourage you to try to get together. Wait a minute. What else did you mention? You don't want him to have any contact with who?
Larry Krasinski,
Krasinski?
Yes.
How do you spell their last name?
it is KORYCIN.
K-O-R-Y-C-A-N,
CIN
C-I-N.
SKI. And that's returned to his home.
Your Honor, can you read this?
Wait a minute. What's Larry Krasinski have?
He's
Was he-
surveillancing my property.
Wait a minute.
He is the,
Wait a minute. Slow down. Was he the one that made the complaint about the dog being at large?
he is, Your Honor.
Okay, well, that's okay, that's fair, no contact with Larry Korazinski then. I think that's fair.
Yeah,
You don't want to have
We'll just bring
contact
this.
with him anyway.
No,
yeah. But I did write him a letter. That was what I was supposed to do.
You already sent it.
Yes.
Well, I walked it over there,
Well,
knocked
we
on
did
his door to hand it to
To
him.
hand
He
it
was
to
home.
him. That's what we did.
What day was that? I have it written down. 12/30/2024.
12:30. And then,
Well, that isn't a bond violation. You've already done that.
Correct.
I didn't
Yes.
have that bond in effect. then.
Correct.
Now I do. So now you can't deliver any more letters or call them or write them or see them or text them.
That's all we had to do.
that was what we were supposed to by law.
Come on, guys. Let's get this in order, please.
Yes, sir.
We'll see you here in a couple of weeks. Have a great day.
Yes,
Go
sir.
down the hall, get your notice. Thank you.
This hearing shows why sovereign citizen arguments often struggle in property cases. The court was not deciding broad questions about financial systems, corporate entities, or theories about who the true creditor might be. The court was deciding a narrower question: whether there was enough legal proof in the record to support possession of the property. One of the most important lessons in litigation is that courts usually reward relevance. A person can raise dozens of objections, challenge procedures, question paperwork, and cite federal statutes. But if those arguments do not directly address the legal issue being decided that day, they rarely change the result. Another pattern appears throughout the hearing. The defendant repeatedly focused on proving that someone else needed to establish additional facts before he would accept their claim. The court, however, focused on whether he could present evidence supporting his own legal right to remain in the property. Those are two very different burdens. In sovereign citizen cases, words like real party in interest, standing, verification of debt, and challenges to jurisdiction are often treated as if they automatically stop a proceeding. In reality, those concepts only matter when they are tied to evidence and the specific legal standards governing that case. What ultimately matters is not how many theories are raised, but whether the court receives proof that satisfies the required legal test. When that gap remains unresolved, the case can move forward even while major objections are still being voiced. And in court, the consequences usually follow the evidence that was established on the record, not the arguments that sounded the most important at the time.